So thank you all for sticking around. I know it's been a very heavy day with lots of information, there's my tribal voice. There is a lot of information that has been shared with everyone here, and rightfully so, because IFPA is basically the tribe's demand to follow the Indian Child Welfare Act in the matter of how tribal nations, pueblos and tribes carry out and see and want to protect our children in the state of New Mexico by developing this high standard that we call the Platinum Standard in IFPA. So what we have before you today, we have 3 fabulous judges before you. One man who needs no introduction, who is my all-time hero, who I choose to be my relative. But we have Judge Romero, and then we have Pueblo of Acoma Tribal Court Judge Randy Collins. And we have Court of Appeals Judge Yohelm.
Jane Yohelm.
Yes, Yohelm. And I'm actually going to let them speak a little bit about themselves before we get into the nitty-gritty of some questions that you all will hopefully take away with you in making these tough decisions when IFPA cases come before you. So.
Well, thank you. And Jacqueline, thank you for, I guess we're on. Thank you, Jacqueline. I admire Jacqueline because of the great work she's done at Isleta, not just in child welfare, not just with New Mexico TIC, but also with juvenile justice reform a number of years ago. I think she's too busy to be involved in that now, but she laid the foundation. I had the pleasure of being involved in part of the work that was being done at Isleta from a distance as a judge in the 2nd Judicial District Court. And I served there for a little over, well, right around 17 and a half years. Enjoyed the work tremendously, and especially enjoyed learning all that I didn't know about child welfare, and I'm still not quite there. There's so much to know, and this gathering today and yesterday goes a long way to adding to what we all should know about the people that come before us, specifically Indian children and their families. So hopefully we will add to your toolbox, even if it's only a little bit. And I think we also want to encourage you to ask questions. This is a participatory session. Jacqueline is going to start off with asking us questions, but certainly you all can raise your hands and comment or ask questions as well.
And what we also left out is those who ask the most questions gets $150 in free play. Just kidding. We know we can't do that. Judge Collins?
Sure. Good afternoon. I'm Randy Collins. I'm the chief judge out at the Pueblo of Acoma, and I'm very happy to be here, and I've learned an awful lot. I'm glad to be on this panel with other people who know much more than I do, and so if there are any difficult questions, just address it to these guys, and I'll just take the easy ones. So it's good to be here. Just by way of background, I was born in a small log cabin that I built myself and had to walk uphill back and forth to school 2 and from 5 miles through the snow. So, and that built my character. But I am delighted to be here. I think this is a wonderful topic, and I think the IFPA really is the platinum standard in as much as ICWA is and was the gold standard. There are 2 statistics that I keep in my mind, especially as I think about this situation. In the 1970s, I think it was, there were statistics that were conducted. And even back in the 70s, which I don't know if many of you can remember that. I can remember back in the 70s, but there may not be that many others who can, who were born then. But in any case, about over 1/3 of Native American children were taken from their families in the 1970s. And 90% of those children who were taken were placed with non-Native parents. I remember when Judge Begay was providing some statistics from her court, her specialized court, and she had largely reversed that, which I think is quite miraculous, through the proper enforcement of the Indian Child Welfare Act. So I want to thank you in particular, for that. I think that you're doing good work, people here, and the folks that are here are learning good and new things, and that's good. And there's still a lot more, certainly, that I need to learn. In any case, so thank you.
I'm the outlier here as a Court of Appeals judge. I will try to be quiet and just overrule these guys when I need to. But no, really, they're the district court judges. That's who you need to listen to about how to do this on the ground, which is the question I'm left with at the end of this day. I think we know what we want to do, and I'm looking forward to hearing pointers from these guys about how to do it. My background, I spent about 20 years before I got on the bench representing parents in termination of parental rights cases in New Mexico, and that included a number of Indian parents under IFPA. So this is something near and dear to my heart that I've been working on for many years. I also, what I'm being told, decided what may be the only New Mexico state case holding that active efforts weren't made last September. I've been on the bench now about 3 years, and so that I did hold that active efforts were not made in an appeal.
Thank you for that.
Thank you.
So we talked a lot about what the law looks like and how it should be applied. Now we need to look at how do you carry out when you're making these decisions and what do you need to do them. And first, we really look at what type of tone is going to be in the courtroom. And I say the tone because we need to look at relationships and how we're treating people when they're entering that courtroom. So if you got to learn a little bit about your community yesterday during the talking circles, some of the icebreakers, that broke the ice in hopes of starting to build the relationships between judicial folks, field workers, ICWA workers, and lay leaders, not to mention our families. Most often what we hear is the fear of going into a courtroom or a setting that is not familiar to most of our tribal families and how they're being mistreated upon walking in, from as little as acknowledging a family throughout the proceedings as a respondent, respondent mother or respondent father. They have a name. Why can't we bring the humanness to our families so it's not a punitive approach when they're coming before you? So to set the tone in the courtroom, you have that ability because that's your home, that's your turf. So I want to start with you, with Judge Romero.
Good.
IFPA's the law, but how does the court make it the truth in the courtroom?
The courtroom is the purview of the judicial officer presiding in that courtroom. And the law is the law. We can read it, we can interpret it, we don't always agree on what the law says, but ultimately it's up to the judge to make the findings and to make the orders that pertain to a case. But more importantly, I think we've learned throughout the last day and a half that IFPA is about children and families and the continuity of that family relationship and the tribal relationship. We have to respect that, just like we would want our own families and our own relationships respected in whatever situation we find ourselves. So family engagement is a very important concept. And how do you do that? It's up to the judge to set the tone. And I recall in the second that our special masters, judicial officers were the ones that had the first contact with the families at the custody hearing. And I'm very blessed that those special masters got it. They were fair, they were even-handed, and they treated the litigants respectfully. They demanded that the attorneys, treat everyone respectfully as well. So that was, that carried over into the adjudicatory hearing if we got that far and the elected judge was handling that case. The special masters had already set the tone, and it was up to us to continue that tone. And it really is, my dear old daddy, 6th grade dropout, I learned a lot from him. My court staff would tell you I more often quoted my father than I did any professors from graduate school or from law school. And one of those simplistic things he said, you just have to treat people like people. We all put our pants on one leg at a time. You're not any better than I am. And I think that has a lot of merit when it comes to being in the courtroom as the judge. Already there's a mystique about the lawyers. They're smart, they went to law school, they all drive BMWs and Porsches. We all know that's not true, especially those of us who practice in family court and in children's court. But there's that mystique that goes along, with what people look at lawyers like. You're going to solve my problems. I created them, but you're going to solve them. Or they look to the judge, oh my God, he's scary and he eats children for lunch. And I need to make sure that I don't make the judge angry, or I don't care what the judge thinks. They stole my kids and I'm going to respond the way I want to. How you welcome people into your courtroom, how you treat people, especially the little ones, the children, is critical. And I learned from other folks, guardians ad litem and kids themselves, that when a child comes into the courtroom and that attorney representing them or guardian ad litem wants to introduce them to the judge, don't sit up on the bench. I used to take my robe off and walk down to the floor of the court, and if it was a little person, I'd get down on one knee, look them in the eyeballs. And I'm not, I'm not very tall anyway. In fact, some of the comments from some of the older kids, when you're down here, you're not really that tall, are you? And I said, no, I'm pretty short, quite frankly. Being up on the bench wearing that black dress makes me look imposing, but I'm not. I'm okay. I don't eat kids for lunch. But how do you welcome the kids into the courtroom? And very importantly, as Jacqueline already indicated, everyone has a name, and we don't always pronounce names correctly. So, if you see that twinge in a person's face when you mispronounce a name, ask them how they pronounce their name, because you want to respect that. It is their name and it matters, and it's something that they value. So what does that have to do with the attorneys in the courtroom? As judge, as the ruler of your kingdom in the courtroom, you have a right to expect of all of the participants in the courtroom to respond in kind. And you do that not necessarily by lecturing to people and threatening them, but by being the example of what you do in court, how you hold, how you position yourself and how you treat other people. Other folks will take note and hopefully follow suit. Similarly with a case, how what questions you ask that may seem innocuous, like of the child welfare worker, the PPW. In your report, you indicate the tutoring service went away. What are you doing to ensure that this child continues to get tutoring? Well, we don't have anybody that will do the work for what we're willing to pay. The child needs tutoring. You need to figure out how to get it. And if you ask the question at every hearing, tell me about the progress the child is making in school. It may seem like an innocuous question, but pretty soon the word gets out among the practitioners to their clients. The judge is going to ask you how the child is doing in school. Pretty soon they're telling you how the child is doing in school without you asking the question. And one of the weird questions that makes a lot of sense to me is at every hearing, once jurisdiction has been established and you're past disposition, ask at every hearing, why can't the child go home today? And people will look at you like you have a pointy head, like, Judge, didn't you just hear the report that was made? Obviously the child can't go home today because. Well, maybe all the rest of us recognize that, but the parents or parent, whomever happens to be there, may not necessarily know, and the child as well, as Kristen just prompted me. The child wants to know why they can't go home, especially the younger ones, especially if their parents told them in a week, we're going to have you back home. Everybody needs to hear what may be obvious to everyone except to the parents. And it also gives the parents' attorney an opportunity to meet with them after the hearing, hopefully, or very soon thereafter, and say, this is what was brought out in court. How are we going to address this? It's in your case plan, or do we need to change the case plan? We need to advocate for a change in the case plan if you disagree with why the child can't go home today. But the short version, which I didn't enter into, is that parents and the children involved in the case are the ones that matter the most. Give them a voice, invite their voice, let them be planners of what's going on in their case, because they know their situation better than anybody else does, including the IFPA worker in many cases if they haven't been honest with them. So give them an opportunity to speak. Sometimes, and this is a little dangerous, a kid will want to meet with you without anybody else present. Generally, at least when I was on the bench, we did that. And usually the guardian ad litem, not the guardian ad litem, but sometimes the guardian ad litem, but usually the resource parent would be in chambers with me and the child. And you learn a lot from these kids. And usually it's not about the case, it's about them. They like to play baseball. They're great, they're left-handed, and they have, they like to bat because they always get on base. Things that matter to kids. Or the teenagers who are worried about, or concerned at least about, the upcoming test at school. Things that matter to them. It has nothing to do with the case generally. And if they want to talk about the case, you need to let them know that if you share with me, I need to share it with everybody else. If you don't want me to share it with anybody else, the attorneys, your parents, and everyone else in the courtroom, then I can't hear what you're going to tell me. Or I can hear it, but I can't take it into consideration. There are ways to giving everybody in the case a voice, and we just need to be creative about that. I'm going to stop there because Jacqueline has many other questions.
Thank you. Judge Ohalem, Judge Romero just spoke on the humanistic perspective, giving some examples that are actually put into IFPA. What is the judge's role in the compliance with the Indian Family Protection Act?
In ensuring compliance?
Yes.
Well, I think the judge has the central role in that. And, as we've heard today, I think active efforts is probably the heart of the act. And I think that the court has to understand what that means, and as Judge Romero's talking about, ask questions so that CYFD and the ICWA worker and other people with information give the court that information. That, what I've seen in representing parents in both ICWA and non-ICWA cases is that forms are used. Every record proper I went through in an appeal for a parent looked the same. CYFD, at the end of every hearing, it would be checked off, CYFD made reasonable efforts. And if it was an ICWA case, CYFD made adequate efforts. And I think that IFPA does a great job of giving you tools to avoid that. It requires, I have a list of 12 sections that require CYFD to report and have evidence and present it to the court at every review showing in detail what active efforts they have made. And if you enforce that and have CYFD write up beforehand proposed findings of fact that are detailed findings about what they've done in that time period, it becomes manageable for the court, I think, because CYFD should be doing the work, not you. but you should be holding them to doing that work. And so that's a really, really important example. And, you know, I don't know whether we're going to get to a discussion of reasonable efforts, but one thing that really hit me today in listening to everything today and last night was, I think many times, and, you know, I've done this too, I've sort of construed active efforts as, well, they have to do more. And I think that's not the answer. They have to do it differently. They have to actually look at the facts and circumstances of the family. And that phrase is in IFPA. And I think that's the most important phrase in defining active efforts. And, you know, the cases that I've seen, the clients I've represented where I felt they got a raw deal and it wasn't done right, almost all of them were unusual in some way, as is every case really in this area. But these were a little bit more unusual than usual, than the usual unusual. And, you know, which just made the forms be even more off. What CYFD does. That this idea of thinking about the tribe, thinking about the family, thinking about what the child's situation is, and focusing, frankly, on the child as much as on the parents, because maybe it's a case where it's, you know, the parents are going to have great difficulty getting the child returned, but there's still the child and the child's family that you need to make active efforts for, or CYFD needs to make active efforts for. And, you know, I think the thing I'm seeing missing is creativity. You know, I used that the other day and blushed a little because that, you know, but it's individualization, and we talk about that with all parents. But this really requires the social workers to be looking at what a family needs and individualizing it, and I think that's what active efforts are. And this act gives the district court great authority to demand detailed reporting from CYFD on what active efforts are being made, and, you know, allows the court to examine the treatment plan and talk to everyone in the court and really be sure that it is not necessarily the rote treatment plan. And, you know, there are families that probably works for, but if this is not a family that's going to work for, to get that dealt with out front, rather than coming to a termination of parental rights hearing, which, you know, I admittedly have a skewed view, because that would be when I would tend to get a client, was after their rights had been terminated, because it was an appeal. But, you know, what was missing was from the beginning, nobody really looked at the family and what they needed and did that, as opposed to doing CYFD's usual checklist.
So you talked about creativity and you talked about active efforts, which we've heard a lot about today. And we also heard that we can't do this work alone, and it's just not the sole responsibility of CYFD to follow and implement IFPA. It is all of our responsibility. With that said, how can the court, or how does the court assure that not just CYFD, but the guardian ad litems, the youth attorneys, and the respondents' attorneys assure the meaning of IFPA is realized by moving to take a more vocal role in advocating for their child? And I'm actually going to leave it to all three of you.
The only thing that I think I might add to what my esteemed colleagues have said is the tribe itself. The Indian Child Welfare Act, I think it's in section 1902 or 1903, under the purpose, talks about best interest of the child and the tribe. And so there's a conjunction and between the two. It's not either or, it's and. Now, it doesn't mean that one is done at the expense of the other. It means that both have to be done together. I think that we're looking to some degree, when we're looking at tribes, if you're putting in a a westernized, I hate using these, Western, Eastern, whatever, but a westernized notion of things. You're looking at the idea more of collective rights or group rights. And it is for some folks in contemporary American society an odd notion, not for the folks in this room, but just, in general. If we're looking at the best interest of the child, the argument goes we should just look at the child. But from what I've heard today, especially when we're looking at the cultural covenants that they're talking about, you're also saying, well, if we want the best interest of the child, how is the child going to fit with the tribe? Because the tribe is where so much of the identity comes from. And that's what we have to look at, and that's part or considered along with what the best interests of the child are. Now, I'm not saying it's an easy determination to be made, and nor am I saying that here are 10 factors that you need to look at. I do think that the answer will emerge more clearly over time. The only way that I can put that is just A, as a matter of faith, and hopefully a matter of faith, and B, when I think about Aristotle and the discussion of the dialectic and trying to arrive at the truth, it's a conversation that takes place over time. And you define things and you redefine things, and that helps us get better. But it requires all of us picking up the laboring oar and working together on it.
Many of you have heard me say that, particularly when it comes to requests, when it used to come to requests for continuances, knowing that that's disfavored in child welfare law. We cannot delay proceedings. And I used to say something that I wish I had thought of myself, but I heard a judge from North Carolina say it, that we need to change our paradigm. We need to stop focusing on the needs of the attorneys and judges and focus on the needs of the children. And I would add the needs of the family and of their tribal partner, the tribe that they come from. So it used to be, we need to view these cases through the eyes of a child. And this particular judge made the point that when you were a little kid on summer vacation and you were having thoughts of Christmas, it seemed like it was 100 years away. And it seemed like that to a kid. And for us, for me personally, the older I get, the faster time flies. I think there's a message in there for some reason or another. But I'm still trying to get over the fact that it's not the end of January anymore, because even in my retired state, time flies. Yeah. Time is different for kids than it is for adults. They can't afford for us to wait. They are, usually I used to hear in court kids saying, when is this case going to be over? I want to go home. And we're talking about continuances for no good reason. We cannot delay what's taking place in the lives of these kids. With regard to the reasonable efforts and active efforts, let me focus a little bit on reasonable efforts, which are remotely related to active efforts. But a survey was done by a judge in Georgia, kind of an informal, non-technical survey of some of the judges who are members of the National Council of Juvenile and Family Court Judges. And the question simply was, how many of you have ever withheld a reasonable efforts finding? Very few of them actually had. And what was even more shocking was the response to the question, how many of you have granted a reasonable efforts finding even when you knew that reasonable efforts had not been made? More people responded yes to that question than to how many people have withheld reasonable efforts findings. I was always troubled by getting the initial affidavit with the petition that was filed alleging neglect and abuse. And on the strength of that affidavit, which at least many that I read were way too long, didn't go to the crux of the matter, and left you wondering whether it was contrary to the welfare of the child to remain in the home. And yet I am embarrassed to say how many times I didn't ponder that any further and still signed off on the ex parte custody order. That's a critical decision that needs to be made, and it shouldn't be made lightly. Is there enough information in that probable cause statement, otherwise known as the affidavit, to support an ex parte finding that it's contrary to the welfare of the child to remain in the household and authorize that removal? I would suggest to you that it's not a decision, a finding to be made lightly. Neither is it to make a finding that reasonable or active efforts have been made when you have questions about whether those, whether you can hang your hat on those findings. You're going to sign the order. Are you doing that simply because you're in a hurry to get on to the next case, or it's just another case? It's not just another case. As someone has mentioned, Jacqueline, about individualizing each case, treating and recognizing that no two families are the same, and no two children in that family are the same. Each one has different needs, and we need to be mindful of what our role is. Finally, I have a problem with what I hear so much in the media, at least locally in the Albuquerque area. This whole system is about protecting children. It's a child protection system. Well, children don't occur in a vacuum. Children are part of a family. They're part of a tribe. Isn't it about more than just protecting the safety and welfare of a child? That's paramount. We know that. But children belong best, function best, grow best when they're in their family of origin, as long as they're going to be safe. Are we making as stringent efforts as we should in keeping families together as we are in removing children from their families? I understand that that's moving in that direction, slowly, but it's up to us as judicial officers, up to you all as judicial officers, I'm not one anymore, but to make sure that the law is complied with and that you just don't enter findings because, you want to move on to the next case. And because this is just another case, I've seen this before. Different family, but oh well, let's move on to the next case. I want to never forget what I heard Ms. Krepnick, Veronica, talk about this morning, and how decisions that were made impacted her life. Even though she was lucky to be in a home that loved her, there was still that hole in her heart and her spirit about what needed to be filled. I hope that with last night's experience in the talking circles and what we heard tribal partners teach on today, that we recognize that 20% of the iceberg we're seeing leaves much to be desired. There's much more to what's going on in each individual child and each individual family than meets the eye. If we don't ask questions from the bench, we'll never know the answers. We need to ask questions. I heard a saying some time ago that inspired me for a day or two anyway, challenging judges to do better. And that saying went something like, judges complain, well, the attorneys aren't doing what they're supposed to. But the saying goes something like this, or the axiom, as the bench goes, so does the bar. And as the bar goes, so does the bench. We're all in this together, a saying that I'm sure many of you who practiced before me were tired of hearing. But we are all in this together for a common goal of providing positive outcomes for children and families. We're not the enemy. We're all in this together. We're all part of the same system. We need to work together, and that comes about by ensuring that the spirit and the intent of IFPA in Indian child cases is fully complied with. Not just the letter of it, but the spirit of it, the spirit of collaboration and working together.
Let me just add something. I agree that I think custody, that the decision on custody is the most overlooked important point in a case. And it's partly because of the state law requirements that really don't provide for a lot of due process at that stage. And that's one of the things ICWA and IFPA improve upon. I mean, the requirement that CYFD make active efforts and show the court that they have made active efforts to keep that child in their home, and that there be a real danger that justifies custody. Those are big improvements, and I think especially, starting with ICWA, that was the focus in a lot of ways of Congress. They saw that children were being taken out of their homes. I think there was Minnesota, there was one state where it was 17 times the number of children taken, the percent of children taken away in Anglo families. And it was custody that is a lot of the focus, that decision of the original IFPA, and it's still here in IFPA, and we tend to focus on the rest of it because that's where a lot of the work of the court is. But that initial decision is really, really important, and to take that seriously and to realize that there are big protections built into this law, and that CYFD does have to show active efforts before they bring that affidavit to you. I mean, if it's an emergency, obviously, if it's active physical abuse or sexual abuse of a child and that's shown to exist, you don't have much choice. But in the really majority of cases where that's not at issue, but there's a real question, should this happen or shouldn't it happen? This act provides many more resources to the court to really evaluate whether that initial decision is the correct one and recognize its importance.
Thank you. When you talk about the importance of asking the questions and determining whether or not active efforts have been made in making these decisions for our children, for our colleagues here that have never had an IFPA case or an ICWA case come before them, can you explain the difference when you're presented with reasonable efforts versus active efforts, and what is the judge's role in determining whether or not the department has truly made those efforts to a judge that has never been presented with such case?
Well, speaking from a tribal perspective, actually, Donalyn gave me this definition, so if it doesn't work out, you can blame her. All right, so reasonable efforts, let's say somebody needs counseling. Reasonable efforts might be, here's the name of a counselor, and they can take you on. I've telephoned them or whatever. Active efforts is, all right, maybe you need counseling. I'm going to make sure that you get driven there. Either you've got somebody in your family who can take you. If there's not, is there another alternative? What can we do? Seems to me that's the difference. And it strikes me that, building on the question that was asked before, I like one thing that Judge Romero said about all of us being in this together, and that to me also means the judge as well. So not sort of sitting back and saying, here are 10 impossible things that I'd like that you should have done and that you didn't do, and now I'm going to chastise you about this for the next half hour just to show you how much power I am and how good I look in this robe. Which I don't, by the way. But I think that instead, trying to suggest ways for people to be able to do things, trying to assist in that process, it doesn't mean that you allow somebody to avoid the issue. You certainly don't want to do that. It's in the law. You got to enforce the law. That's what you're there for. But at the same time, you don't have to make impossible demands. What you can say instead was, well, did you think about this? Did you try this? Did you try that? And doing that and asking those questions at a time when things can be fixed and corrected, not when it's impossibly late, not when it's too late to do anything and everybody's backed up against the wall. I also think, as these folks have said, is looking at it from the perspective of everybody in the courtroom, including the child who's impatient and wants to get on with it. All right. I see ICWA from the standpoint of, do you want the case? And my answer always is yes, except in perhaps very specialized circumstances where for some reason we don't have the resources. But I even think, even in situations, and I haven't had this in an ICWA case, but even in situations where the where the court may be far away. The one thing that the pandemic has taught us all is that you can use Zoom or Google Meets or whatever in order to bring people, witnesses closer together, in order to, and in doing that, then, and in doing that, you bring the tribe in, which, again, I feel is very important. I think we've got to think about the child, and we've got to think about the child in the context of the tribe. So, in any case, that's, as Forrest Gump says, that's all I have to say about that. So.
One of the things that troubled me, and I think with the new judges who are now in the Second Judicial District Court, along with the seasoned judges, Judge Parmel and Judge Ward, that this level of performance by attorneys in the courtroom is rising, perhaps not as high as we would like it to. But I was always troubled by the fact that some of the folks that ought to be the loudest advocates, the most zealous advocates for kids, were mum. They didn't object to anything. And too often, it seemed as though they were siding with the department by their silence. By their silence, they were complicit. And even worse, parent attorneys were showing up, seemed disinterested in what was going on. And how do we raise the level of advocacy among those who are representing the most vulnerable, the children, and to some measure the parents who are in a very vulnerable, threatened, misunderstood situation? I mean, one way to do it is scold them and wag your finger at them. That's probably not going to get a whole lot of results. Another way is to visit offline with those who supervise these folks. And maybe even better yet is to call a meeting and they will come, just of those who are legal advocates in your courtroom, and express what your concerns are and hear from them, because you might be misperceiving the situation altogether. On the other hand, maybe no one's ever challenged them with that. How do you encourage greater advocacy, more involvement by the parents? Attorneys, by the children's attorneys, by the guardians ad litem. Too often, I felt like I was the guy making the department feel uncomfortable because I was asking all the questions, when the guardian ad litem or youth attorney should be, saying, Judge, we're, based on what's been reported, we're asking that you withhold your reasonable efforts finding, or that you find that reasonable efforts weren't made in this case, or active efforts in an ICWA case. Rarely ever heard that. I did hear it, but every once in a blue moon. And I know there were causes in many of the cases for someone to ask that. And that left it to me. And so, one of the things that at least tried to cut him a little slack and say, well, based on what's been reported today, I'm unable to make a finding of reasonable efforts. We're going to continue this hearing for 30 days, and we'll be back then to see if anything has changed that warrants a finding of reasonable efforts. In many of those cases, it was amazing what takes place in the next 30 days, because you brought to the attention of everybody involved what was lacking, and that's our role as a judge. Some people say, well, you're not supposed to be an advocate. You're supposed to call balls and strikes. Maybe in other courts, not in children's court. You can be an advocate by asking questions and by, I hate to use the word demanding, but that's kind of what it comes down to, wanting answers. A judge, we're not only are we not able to, we're not allowed to go out and investigate matters on our own. It's incumbent upon those who can do that to provide you with answers. And you've all heard the adage that a judge's decision is as good as the information he or she gets. And, part of getting that information is asking, probing, incisive questions, which sometimes label you as the mean old judge who makes the workers cry. I was accused of that. They made me cry sometimes because they weren't doing their job as I perceived it.
The definition of active efforts in IFPA is quite helpful as a guide to, what ought to be happening. And it comes largely from the Code of Federal Regulations under ICWA. And one of the things that I hadn't remembered when I recently reread them was that one of the aspects of active efforts is also sort of more investigation of the family circumstances by CYFD. And someone mentioned today periodic investigation, not just assuming everything has been the same. And that's something that's quite different than what I've seen with reasonable efforts, if it were actually being done. And is quite helpful because often it looks to me in reviewing a file that a case got stuck because nobody ever reevaluated the initial assessment of the family and the initial plan, even when it kept not working and not working and not working. Nobody stepped back and said, well, maybe we missed something or maybe there's another way to approach it. And the law really does demand that under active efforts.
I think there's also, it's incumbent upon the court to know at least as much and hopefully more than the attorneys know about the law. As an example, it's very easy for someone to try to put something over you if you don't know what the requirements are. For example, one of the few cases that was a published opinion in which I actually was not overturned. but the issue of notice and the requirement of certified mail return receipt requested. And there was an attorney with the department that was using tracking records, not the return green card, and saying, well, Judge, it was delivered on such and such date. Here's the UPS tracking record. I said, I invite your attention to the statute. It says evidence that it was received, and that's for a purpose, so that there's at least, I think, 20 days more for the tribal entity to respond to the petition. And that assumes they got it and that they got notice. Theoretically, delivering a certified mail return receipt requested, there's an inference that they received it at least, and they can ask for an additional 20 days to respond. But something that technical matters. And when you dig your heels in as the bench and say that doesn't comply with the law, and you get pushback from everybody involved because they want the case to move on, and we're not going anywhere because you're being a jerk and saying that they haven't received notice. Well, that's part of my job, I guess, to be a jerk and demand that the law be complied with. And again, even though that appellate decision focused more on time limits than it did on the rules of the rules set out in the regulations and also clearly set out in federal IFPA, they did touch on it, but that wasn't the focus of the opinion. I still didn't get overruled. That was good.
You know, it strikes me that a lot of times when you hear people say, well, we've done everything that we can, what they're really saying is, it's out of my control, it's out of my hands. And it strikes me that part of what we need to do as judges is to say, no, it's really not out of, here's how it's in your control. Here's how it's within your responsibilities. I get this every once in a while in child support cases where I'll have an individual who owes child support. It's usually the guy. And he'll say, well, I don't have a job. How can I, what can I do? And I'll say, well, did you do any household chores? Did you help take care of the kids? Did you chop wood? Did you do anything at all to demonstrate that you were willing to roll up your sleeves and get involved? That is within your control. So, yeah, maybe you don't have a job right now. And what have you done about looking for a job? How many people have you talked to? Where? Who? So in the context of ICWA and in the context of individuals saying, well, we did make efforts and it was active, well, show how it is within somebody's control where they could do something and didn't do it. And make sure that you do it at a time, hopefully, when they have an opportunity to correct the situation and fix it so that you can move on. And that means rolling up your sleeves and being a part of the solution and not just pointing out the problem. That's all I have to say about that.
On your earlier question on on, how to get the attorneys to be better advocates, I'm noticing that there is a section of this act that requires mandatory training. And I'm sort of looking at Kristen, but for guardian ad litems and youth attorneys, and, I find education pretty effective. I think, you guys have been great. This has been a fabulous conference, and you're probably exhausted, but redoing it for all those other folks would be wonderful.
Well, Twyla has already engaged us in moving forward on presenting some of these points to attorneys, CASAs, other folks that are not judges.
Yeah.
But that's a beginning. We're basically priming the pump by that training. It's still incumbent upon the judges to continue the education by requiring compliance with the law and by asking questions. Otherwise, if they're like me, you hear it today and by tomorrow I don't remember what I heard. We need to be reminded frequently.
Well, and it makes it, if the judge invites it, it certainly makes it easier for the attorneys to respond, rather than feeling like they're going to meet a brick wall or worse if they raise something.
Well, if you're anyone like me, this conference, even though I've lived this for about 16 years being in the field, IFPA and ICWA is touchy-feely for me, and you all have obviously pulled on my feeling strings. And when we go into the court as judges, and we've heard some testimony about it earlier when we talk about bonding and attachment, and I'm not sure if anyone had any conversations on bonding and attachment last night, but what are some strategies that you can offer your colleagues when they're challenged with areas of bonding and attachment, knowing that in IFPA, bonding and attachment cannot be used to deviate from a number of areas in the law itself, but also to ensure that when we have our own biases that we may not have yet recognized or we may not have yet addressed, how can we ensure that when we are on the bench, or you are on the bench, not me, that these decisions about bonding and attachment are not going to be more harmful to our children by keeping them out of the home for those reasons?
My understanding of the rules, the CFSRs, the guidelines, is that federal ICWA provided for how, for best interest of the child by requiring that the child be placed with another family member, with another tribal member, or even another Native American family, perhaps not affiliated with that particular tribe. So if that were done faithfully at the beginning of removal, you wouldn't have the bonding with a resource parent who's doing the very best they can to treat that child as their own child and to bring them into the family, but only to have to later part with them. If we did it the right way, if we demanded on complying with the placement preferences, and I know, I used to hear it, I'm sure you all still hear it, we're asking the court to find that deviating from the placement preferences is appropriate, and I forget all the technical language, but you would ask why, and they say, well, because we don't have any ICWA foster families. Well, why don't you? Why don't we ask that question? Why don't you? Or why aren't you collaborating with the tribal partners to see if they have someone that's licensed within their community to be a resource parent? We never, I am guilty. I used to, bark a little bit about, well, why don't we have more ICWA, families that are Native American, and never get an acceptable answer and leave it at that. I didn't probe enough. I didn't ask the questions. I didn't call a meeting to say, what are you all doing to not have that be the answer, so that we don't have this problem 9 months later, 12 months later, when a resource family is filing a motion to intervene and they meet the requirements for permissive intervention, and they're going, their agenda is they want to adopt that child later. Meanwhile, the biological family, who may be in substance use treatment for 9 months faithfully, still has not completed the training, but now, you know, the argument is, Judge, we're at 15 out of 22, and we have no choice but to file, you know, change the plan to adoption and file for TPR. What are you going to do as a judge? Who's, you know, when they argue that the child is bonded to this resource family and not to the family of origin, what have we as judges done to ensure that meaningful family time has taken place? You know, did we ever ask about that at the beginning of the case? You know, meaningful family time, formerly known as visitation, which some people still call it that, but family time is a more neutral, more friendly term of what it really means to have children and their siblings and their parents together. That is the number one catapult to reunification, meaningful family time. When parents get to see their children, when children get to see their parents, and you match that up with meaningful family time, the likelihood is, not in every case, but that parent is going to step up to the plate and do what they need to do on their case plan. If you keep the kids away from them, part of what I used to hear, even in court from parents, is, what's the use? You guys have already decided that my rights are going to be terminated. Why should I do anything? And then you don't see them in court for the next couple of hearings that they should be at, and you wonder why. What did we do to encourage their participation? We can do more.
One thing that I would say is it might be useful to get the tribal court where you can involved. I had a case not too long, well, actually it was a while ago. It was in state court, and in fact, I think it was Judge Parnell's court, as a matter of fact, and he did a very good job, I might add. But what happened was this issue of bonding, in the sense that the tribe never really got notice about the particular case, and the agency decided that the relatives of the child would not be, who were Acoma, were not appropriate, because one of the parents had gotten a DWI like 10 years before or something like that. The father, I believe, worked for the Air Force, and the mother had a very responsible job. The resource parents, though, were very, very nice. There's no reason to, to gainsay anything about them. But Acoma never received proper notice about the case. We only came in and intervened in the case as soon as we found out about it, but later. So if the intervention had been done right away, there wouldn't have been that time lag. There wouldn't have been there wouldn't have been the time when the child would have spent so much time with the resource parent. We would have been able to correct the situation much, much earlier than what happened. I have had some other cases where jurisdiction's been a little bit confusing between state and tribal, and what we've done is we've held concurrent jurisdiction. In one case, we even had a double hearing. There was myself and the state court judge presiding in the same hearing. It's a little unusual. Maybe not for the appellate court, but it's a little unusual. But we didn't know who necessarily had jurisdiction. Rather than arguing about that, we wanted to bring everybody in as quickly as we could and bring them in together to see what solution we could effect to reunify the kids with their family. So I don't know. That's what I would do about that. And that's all I have to say about that.
Judge Collins, you touched a little bit on contacting the tribe. If a judge is, if they have additional questions or wanting more information on the child's tribe or their culture, what can be done to ensure that they're receiving the proper information on the child's specific tribe and culture?
Well, I think now New Mexico Tech, the social workers, they do a really good job, I believe, at communicating with state courts and state about the various tribes. In addition to which, you have the Tribal State Judicial Consortium, and I think, and I've participated on that for quite a while, and I think it's done a very good job in opening up lines of communication between state and tribal courts, so that there's a real exchange of information. I mean, the fact is, I'm here at this conference because I was invited by the social workers and various state folks. So I think that things are opening up, and I think information is getting out there. Since I've been out at Acoma, I've seen a great deal of change, and folks like these people right here have done, so much. And I really appreciate that.
Judge Yohalam, because tribes, pueblos, and nations have grown tired of being ignored and not complying with, and the state's not complying with the Indian Child Welfare Act and struggling now with IFPA, IFPA has 15 sections of invalidations if there are findings of noncompliance. What, if any, are there are the judicial impacts and or impacts to the attorneys themselves on these invalidations?
So you're saying invalidating like a termination of parental rights or an adoption?
Specific areas, specific sections in IFPA, there's 15 of them, starting with notice.
Right, that could invalidate subsequent to
Correct.
a decision. It's, I don't know that I have an answer to that. It has come up, I think it's mentioned in I never know what to call the cases. I call it the Marlene C. case, the one ICWA, New Mexico Supreme Court decision. I think it is mentioned in that case because it came up in that case as a way, there was an issue about whether the appeal was timely filed, and it was some issue about the court's jurisdiction on appeal. And there is an acknowledgement that ICWA is different, and I think there's a Court of Appeals case as well that mentions it. And I've also noticed that there are a couple of recent Court of Appeals decisions that consider the abuse and neglect finding, even though the appeal is filed after the termination of parental rights. And I was actually wondering about that, and I think it's because of the invalidation provisions, so that's the legal effect that I've seen. I don't want to give more opinions than that. I think it's a pretty undeveloped area of the law still of how we deal with that.
When something goes awry because attorneys and judges didn't do what they were supposed to do, certainly the impact on additional hearings and having to redo the case, the impact on the system is certainly important to consider. More importantly, the impact on the families and on the children, because now they're back in another holding pattern with those of us highly paid professionals didn't do our job. We need to make sure that we don't let that happen, because the ones that suffer the most are the children and the families who are waiting on us to make a final decision and they can move on with their lives.
Well, in closing, and I'm sorry we ran out of time. We have a slew of questions still, but I'm sure that any one of us would be happy to speak more at length. I know Lindsay Fuchs, who I don't see here, oh, there she is, can probably offer some tools that she utilizes in her court. Judge Begay, I know, is instrumental in that as well. And of course, Judge Romero and the rest of our panelists up here, if you have any additional questions that we didn't touch on. But before we leave, this, I hope, has demonstrated the ability that even though IFPA is going beyond the regular check mark approach, we truly are demanding action, and our children's lives require action. They require a chance and they deserve a chance. And with genuine efforts, working together, collaborating, and having effective communication within all parties that are involved in our children's lives, we truly can make this happen. We can give our children the life that they deserve and that they demand. And that has been proven through IFPA Court, which is, I wish was applied throughout the entire state of New Mexico, because it demonstrates a lot of areas that are positive for our families. They're spending less time in the courts, especially when the tribes are involved. They are with their family, and that is key here. This is not about looking for relative placements or, about preferred placements. It's about linking them with their family. First and foremost, it's about them being with their family, which will leave them immersed in their tribal communities, that will give them the tools, the language, the traditions that are necessary to be the future leaders in their tribal communities. And I hope that when you leave here today, you remember our littles that came before you yesterday. You remember the examples that were provided here today. You are reminded of the cases that are coming before you, and you are reminded of Veronica and her story that she shared. And although she had a beautiful upbringing, she still wasn't home. And she missed out on a huge gap to be with her biological family that she could have been enjoying all these years. So we all have that ability to make these decisions combinedly and effectively to the true spirit of our children and what they deserve. So please, I hope that you take this in a different perspective that is more meaningful to you, and you remind yourself, if this was your child or your grandchild, are you doing the best to make sure that they are going to be with their family? And are the decisions that you're making, are they true to them, you, your culture, and your community? Thank you.
Thank you, sir.
Thank you, Jacqueline.
Thank you.
Thank you.
If I could just say something.
Enlighten me.
Oh, yeah.
While we're waiting for questions, I guess I have one more mini sermon to preach. And this comes from my dear friend and mentor, Judge Michael Martinez, may he rest in peace, who informed me that being a children's court judge was being different from being a judge in any other court, perhaps with the exception of family court, where we have so many similarities. But he said, you need to get out of your comfort zone, out of your chambers and out of your courtroom and into the community. Perhaps first and foremost, into your court community. There are folks there that work very hard in the clerk's office, the folks who do the security at the front door, that light up when you say, thank you for what you do. Judge Martinez had a different approach. He used to go around and say, you guys are lucky. If it wasn't for us, you wouldn't have a job. Of course, they knew that he was poking and probing, and they would say, well, if it wasn't for us, you couldn't do your job, both of which are true. My point is, when you're invited by a tribal partner to go to their feast day, to go to whatever other celebration they have, if you don't seize that opportunity, you're missing out on a chance to get to know your community better. And that makes you a better judge, because you understand better and more importantly, the people see you. You're not as tall as they thought you were. You're regular people. You don't have fangs coming out of your mouth. You're actually okay. And they may have greater confidence in appearing before you that you're going to give them a fair shake.
Just wanted to thank everybody who helped put this conference together. It's been incredibly informative and helpful, and I know many people worked very, very hard. So thank you to all of you, to the tribes, to Isleta for hosting this, and yeah, it's been wonderful.
Thank you.
Thank you. This has been an amazing program, and a lot of work went into it. So I want to thank a few people that really helped plan, that spoke, that sat through some tough meetings and were really open. And so it just took so much work. First, I want to start with Governor Max Zuni, the absolutely adorable Isleta Head Start dancers, Cindy Aragon, Regina Begay Rowanhorse, Julie Bird, Terry Chavarria, Chief Judge Randy Collins, Veronica Krupnik, Donalyn Saraceno, Isleta Casino, its staff and audiovisual team, Celeste Smith, Virginia Tenorio, Crescencia So, Lana Valdez, Marcia Vayo, Jacqueline Yalch, Judge Jane Yohalam, and then, of course, AOC put a ton of work into this. Jennifer Vieira, Joanna Jimenez, April Lucero, Brian Auburn, Selena Jones, Twyla Hoon, Allison Pock, and Judge John Romero and Chief Judge Marie Ward also were all at all the planning meetings and had a huge role in this. So thank you all very much. I just want to say that I don't think this is the beginning, or that this is the end. I think it's the beginning, and I want to continue to have an open dialogue. My door is always open, and one thing I've learned in my newest position is that when you bring stakeholders together, you go in with an open mind. That truly is the best way to improve our justice system. So thank you so much. Thank you, everyone.